Okay.
Morning, everyone. Good morning, everyone, and a very warm welcome to you all. Thank you all for joining us today for the webinar on making submissions on the revised draft paper. My name is Tanya Shabalala. I am going to be your moderator for today. I'm speaking on behalf of Lawyers for Human Rights and our partners for the webinar, Section 27 and Collective Voices for Health Access. Before we can open the webinar, just a bit of housekeeping rules. Please kindly keep your mics off and please use the Q&A or chat function to post your questions. I'll be keeping an eye on them and I will raise them to our presenters during our Q&A segment. So with that, please allow me to introduce Sharon Ikambaram, who will be opening the webinar for us.
Good morning, everyone, and thank you, Tanya. As Tanya mentioned, my name is Sharon Ikambaram, and I head up the Refugee and Migrant Rights Program at Lawyers for Human Rights. And I'm also a member of Kopanang Africa Against Xenophobia. Just to add one more rule or mention of the chat box, if everyone could please introduce themselves and the name of their organization, if they are coming from any organization, and if they want to be continuously informed and updated, to include any contact details. I think that this seminar takes place in a global context where we are seeing an increased criminalization of the movement of people. And this white paper, even though it is an improvement on the shocking white paper that was produced in 2024, and where a number of submissions were made, and in particular from NGOs, civil society groupings, individuals calling for it to be withdrawn, we see that it has come back and still has serious problems, which as a non-lawyer, I would say presents to us serious constitutional challenges. And as you all know, policies in our country has to be compliant, consistent with our very, very progressive constitution. This seminar and the policy that's being put forward for our comments also takes place in the context of what is happening in the US with the immigration customs enforcement. And I'm deliberately highlighting that word enforcement. We need to be thinking through, particularly as we deliberate in contributions and submissions on this white paper, to think about how do we move away from enforcement in repression in the way that policy is being formulated to manage the movement of people. And I would go so far as to say that it is particularly affecting Black people, people of a darker skin, and this is a global phenomenon. Today's program very quickly will once this opening and introduction is over, we'll have the overview of the revised draft white paper, and we have a representative from Lawyers for Human Rights, Nico Manusa, who is the manager of the LHR Walk-in Law Clinic in Durban, and he'll just take us through key policy changes and implications for communities. And I think this whole seminar is rooted in empowering us to be able to make submissions, following up on the work that was done in 2024 in helping us to do this. Then we have thematic panel 1, which looks at legal perspectives of various civil society and relevant stakeholder insight. And we have representatives from Stats SA, education rights impacts, and collective voices. And then we'll go in for about 10 minutes with a speaker from LHR guiding you into how to make effective submissions. We will have a open question and answer session. But as Tanya said, I want to ask you to please put in any comments, any questions, or resources that you'd like to share with us in the chat box. And then we will have a final session of next steps and how to follow up. Various organizations may indicate that they'd want us to be endorsing submissions, which is also always welcome. And then we will have closing remarks and a vote of thanks. But just to start off by saying thank you to the team that organized this webinar. And it's in my final comments is to understand that what we are doing today is empowering ourselves, which is part of strengthening our democracy, which is in crisis in South Africa, and all towards holding the state to account. Back to you, Tanya, with those opening comments. Thank you.
Thank you very much, Sharon, for setting the scene so clearly. It is a pleasure to introduce our first speaker, Nico Manyusa, from Lawyers for Human Rights, and he will be focusing on the key proposal, policy proposal, as Sharon has mentioned. Nico, thank you for being with us today. Over to you.
Thank you very much, Tanya. I'm gonna share my screen. And if someone could indicate if you can see what I'm sharing. Can anybody see?
Yes, we can see. Thanks, Nico.
Okay, perfect. Thanks very much. So, yeah, as Sharon indicated, my name is Nico. I work for Lawyers for Human Rights. I'm based at the Durban office. I'll be very quick. It's a long document, and I only have 10 minutes. So, you'll have to please understand that. So just to give a little bit of a historical context, this white paper started, as this one in particular, started in 2023 on the 10th of November by the previous Minister of Home Affairs, Dr. Aaron Motsoaledi. We made comments, and he introduced what he called a final white paper in April 2024. After that, he was replaced by the current minister. And I must mention that the previous white paper was calling for South Africa to withdraw from the 1951 Convention and other international treaties, with a view of ratifying these international treaties again, but with reservations. But after the GNU, the Government of National Unity, and the new minister, we now have, it's basically the same white paper, hence they use the word revised. And they are now saying they are not going to withdraw from the 1951 Convention. But mine is just to give just an overview. But as you can see, we come a long way now with this white paper. If you can look at the number of years there, 2023, 2024, and 2025. So the process for making law is you start with a green paper and then white paper, which will be tabled in Parliament either by the minister, and if it passes the Parliament, it becomes an act of Parliament, which is signed by the president to become law, in the same way as we have the Refugee Act, the Immigration Act. So that is the overview of the process there, and we are at the second stage. But the process requires us as the public to be consulted, and hence we are allowed to make submissions on what we think of the proposed law, which will soon become a bill if we get there. So Home Affairs is basically divided into three main components: the civic service, the immigration service, and refugee protection service. These are the three main components, and the civic service basically deals with issues relating to birth, registration, marriage, death, certificates, etc. And they are the custodians of the National Population Register. And the immigration side, they deal with a lot of things, but primarily, and for purposes of this presentation, the issuance of visas to migrants and permanent residents. And lastly, we have refugee protection. And we have the Refugees Act, which is applicable to asylum seekers and refugees. So my presentation will basically also be divided into these three categories. So according to the Department of Home Affairs, they want the new law regulating migrants, refugees, and asylum seekers to basically prioritize certain priorities of the South African government. At the top of the list being job creation and economic growth. But at the same time, they insist that their proposed policies will comply with the law and international law. But what I would want us to note is that this proposed law will not apply retrospectively. In other words, it won't require those who are already asylum seekers and refugees, for example, to have to apply for asylum afresh. So on the civic side, the one thing that I've noted that I think is particularly important is the proposal to introduce the intelligent population register, which I'll discuss next. So they say the intelligent population register will replace the current national population register. So at the moment, if one is born in South Africa, that person has to be registered into the national population register. It is basically a database which record people who are born in South Africa. So they say this national population register is outdated, and at the moment it doesn't record the birth of people who are born of people who are not South African citizens. And you will notice that children of asylum seekers and refugees, for example, have got what we call handwritten birth certificates, and therefore their birth is not registered into the National Population Register. Hence, they are proposing that we need to have what they call intelligent population register. Now, what is this intelligent population register? It will record the birth of everyone, irrespective of the documentation status of their parents. They say it is universal and inclusive. However, it does not confer legal status. So it means it won't give you a visa or a permit. They just record your birth, regardless of your parents' documentation status. And so in practical terms, it might be that we will have Home Affairs officials at the clinics and hospitals, and before one is discharged, or maybe I should say before the mother is discharged from hospital or clinic, the birth of this child will be registered, and the details will be in the intelligent population register. And so the Home Affairs is calling upon people to express their views on that in as far as the civic side is concerned. Now I'm going to move to the immigration proposals in the interest of time. The first thing is a process which they want to introduce, which will affect the granting of visas, the issuance of visas. And these are visas which migrants apply for. So they want to introduce a new system called points-based system. In terms of the points-based system, visas will be issued to people with certain skills and qualifications, and those who contribute effectively to the economy of South Africa. Remember, we've got these state priorities: job creation and economic growth. And so the points-based system basically will prioritize people who are contributing positively to the economy and with certain skills. They further will introduce new visas. Some of the visas we need to note is a business visa, which will be replaced by an investment visa. The critical skills visa will be merged with general work visa and will be replaced by skills worker visa. And to apply for this visa, you must be sponsored by an employer. One other thing that we need to note is a new visa. I don't know the exact name, but it will be to give legal protection to people who are displaced by environmental factors. There will also be changes in permanent residence. So according to Home Affairs, they are very concerned about population growth in South Africa. And they feel like there's a lot of people who are getting PR. And so they want to propose changes in the way people apply for PR and the way they are granted permanent residence. And so in practical terms, it might be that they might say from January to June, no one should be allowed to submit an application for PR. And then they will resume applications maybe later in the year. Hence, there will be a window period for PR applications. And those who will be eligible to apply for PR will be those who've got more points based on the points-based system. So it will no longer be based on long stay. For example, if you are a refugee and you've been residing in South Africa for more than 10 years as a refugee, you automatically qualify to apply for PR. And that will soon change. It will no longer be based on long stay, but it will be based on scoring more points in terms of the new system of points, which we are not too sure of and how it will work to accumulate more points, but they will prioritize people with skills who have invested, etc. Other matters under immigration is the establishment of specialized courts and single appeals authority, as well as a system that will be in place that will ensure that migrants and refugees and asylum seekers are represented by attorneys, advocates, and immigration practitioners, and not by everyone, as well as introducing fines for overstays. So if your visa expires and you remain in South Africa, in the past, if you exit the country with an expired visa, you would be banned for 5 years, and you'd have to apply to be allowed to be admitted back into South Africa. But that will change. You won't have to make an application and make representations. You will have to pay a certain amount, which I'm sure we'll know soon. So lastly, under refugee protection, there's 4 things that I think are important. One is, which I think is very important, is the first safe country principle, which they want to introduce. This principle will firstly require South Africa to enter into some kind of agreements with certain countries which, according to South Africa, or according to Home Affairs, are safe to host refugees. And so if you are not our immediate neighbor, and when traveling to South Africa, you pass through these safe countries. In terms of this principle, the Department of Home Affairs can reject your application because you have jumped a safe country whilst on transit to South Africa. It's very sophisticated. I don't know how it will work practically because people travel differently. I don't know if we will ever be responsible for refugees from Europe because they come from far. We are not sure if the mode of transport will play a role. For example, there's someone who comes from, let's say you come from Egypt and you take a direct flight to South Africa. Will you be considered to have passed through certain safe countries if you are using land transport? How will it affect you? Some are already having concerns that obviously this will target poor people who can't, for example, fly. But they say we have to share the burden because people, and just to use their exact words, they say pick and choose South Africa. And so South Africa is burdened by refugees and asylum seekers. And so this first safe country principle will basically allow Home Affairs to refuse applications for asylum from people who come from very far and past other countries on their way to South Africa. And now they are requesting that we share our thoughts on this through making comments on this proposal. They want to introduce, it's not really new, but if you are lucky to be admitted into South Africa and you're issued with a Section 22 visa, it will be blank on the right to work and study. Most of you know that if you get an asylum transit visa, automatically it comes with the right to work and study, unless if you're a child, in which case it will have the right to study only. Now, if you are admitted into South Africa, you won't automatically have the right to work and study. You'll have to apply for it when you are inside South Africa. And you'll have to comply with certain requirements, which might be challenging for some applicants, given the nature of, the challenges which refugees and asylum seekers come across. The third thing that I wanted to discuss is the entry requirements. So if you come to South Africa and you enter South Africa illegally, you will have to show good cause. In other words, you will have to provide a valid reason why you sort of jumped the border or entered illegally. I didn't see anything in the white paper that speaks of the current ongoing litigation. We have a judgment. I think Scalabrini went to court and the good cause requirements have been declared to be unconstitutional, and the matter was referred to the Constitutional Court. So for me, this is a little bit problematic because this white paper is silent on that. Perhaps they are hoping that they will be victorious in the Constitutional Court. It is not clear. And lastly, there will be a single appeals reviews authority. And that means that the refugees, RASA, what we used to call RAB, will be merged with the Standing Committee for Refugee Appeals, SCRA, and then they will form one appeals and reviews authority. So we will not have RASA and SCRA in the near future. We will have a single authority to deal with reviews and appeals and other internal applications, including citizenship applications and exemption applications. And lastly, the RROs will be moved to the borders. So these are some of the notable changes and proposals into the Refugee Protection section of the Department of Home Affairs. I hope I didn't waste a lot of time, and thank you. Over to you, Tanya.
Thank you very much, Nico, for your overview and looking at these potential implications that affect our communities as well as society. As we now move on to our thematic panel discussion, this discussion brings together legal, civil society, and sector-specific perspectives to unpack how the proposed policy framework may affect different communities. We are joined by Diego from Statistics South Africa, Fatima Lahir and Asipe Funda from Section27, Palesa Maloisane from Lawyers for Human Rights, and Thea from Collective Voices for Health Access. We will therefore start with Diego from Statistics South Africa, who will share insights on data, population dynamics, and migration trends. Over to you, Diego.
Thank you very much. Good morning, everybody. And thank you so much to Lawyers for Human Rights for organizing this really important session. I want to reflect on a few things, some of which were touched on in Nico's presentation this morning, and maybe raise a few other issues. It would not be a inaccurate observation to say that the white paper does not seem to appreciate or touch on the use of empirical data as it reflects to population dynamics or as it reflects to migration trends. I don't think there's any part in the white paper where there's a table or a source or a claim that there are so many migrants or that migrants are contributing to this thing or to that thing by this amount. So there's a real lack of appreciation for or the lack of usage of statistical information in the white paper, and I think I would imagine that it's because they feel that any claim that they make can be challenged, or that for every claim there may be somebody who makes an opposite claim. But be that as it may, I think it is an important omission on the part of the white paper that it's not making reference to any data to validate or to motivate for the proposals that they are making. And an important observation in this regard is that it is certainly driven to a large extent by perceptions of migration on the ground. The Human Sciences Research Council conducts a study called SASAS, the South African Social Attitude Survey, and they ask people how many foreign-born people do you think there are? And then in a subsequent study, they asked, how many of these people do you think are undocumented migrants? And the perception amongst people on the ground is that the number of foreign-born people and of undocumented migrants are far, but by a large magnitude, far higher than what they really are. We've counted in the recent population census 2.5 million foreign-born people. And even if you're a little bit skeptical of that and you think that it's too low, and we decide to argue about it, and we settle on 3.5 million people, it is still a lot lower than the 20-odd million people that this study seems to claim are foreign-born people, and of which the majority are undocumented migrants. So this perception that's on the ground is driving the resistance towards a much fairer migration governance, which is what we are all striving for. And because it is the predominant perception, it's the perception that the department through this white paper is trying to address. But in reality, we know that the numbers are really a lot smaller, and we know that by applying some very simple techniques related to the demographic footprint of the people in the country, that it is absolutely impossible that there be the types of numbers of foreign-born people that some people are claiming there to be. I think the one question I get asked the most is always about the number of undocumented migrants. And if somebody is undocumented, or there's no evidence of the person's existence in the country or on any records, it's extremely difficult for myself to come up with an estimate of that. But what we do know is that it is a subsection of the total number of foreign-born people in the country. So if we're saying it's 2.5 or 3 or 3.5 million people, it is a subset of that. It's not something that's more than that. I think one of the other perceptions is that whenever we publish a number, whether through a population census or a survey, that we're only counting documented ones. And that's also not correct, because we are not interested in knowing what the official status or the migratory status of an individual is. Our role as a statistical agency is to count people and to collect information about these people. And that's really the sum total of our mandate. So when I get asked about undocumented migrants and I provide this response, it's a response that's not often very well received. And I think Sharon made reference to the criminalization of mobility, which I think is right at the heart of all of this, because there's only one country in the world that actually estimates undocumented migration. That's Chile. And the reason why Chile is able to do it is because being an undocumented migrant is not criminalized. It is not a criminal offense to be an undocumented migrant. And as a matter of fact, what enables them to estimate this group is that by approaching a public health facility or a public school, one can simply approach them and say, look, I am an irregular migrant in your country, and I would like to make use of the service. They provide you with a reference number, which is shared with the statistical office, and then with that, they are able to make some kind of estimation of the size of that group. But even in advanced societies and economies in Western Europe and North America, there are no real estimates or regular estimates around this, other than those coming from academic organizations. Something else I think I picked up on Nico's presentation was that he indicated that the department is concerned about population growth, and for that reason do not want to issue permanent residence permits anymore. Now, the population growth is not driven by migration, not in South Africa, and not by a long way. Population growth in South Africa is driven by fertility, and that's by a long stretch. The magnitude of net international migration in South Africa is actually extremely minimal. And so the issue of population growth should not be a concern at all. I think something else that I have noted is throughout the white paper, there is a continuous reference of speaking about national priorities. And I think it's those 4 or 5 priorities that we saw in the previous presentation about economic growth, creation of employment, et cetera. And I, it almost seems that seems to be the rationale, or which is being used to justify a lot of the proposals. And I think in addition to those, I think South Africa's humanitarian role, from which it has a inalienable responsibility to promote because of its constitution, because of its Bill of Rights, and mostly because of its history, needs to come through as strongly as possible. There may be the argument that says that we don't have the fiscus to be able to look after humanitarian issues of the rest of the continent, but none of this has ever been tested. None of this has ever been measured to say this is the cost of hosting a refugee or an asylum seeker or an economic migrant, and this is what it costs us, and this is what the migrant brings to us in economic terms. So I think before such claims are made, it's important that these claims be tested by independent academic organizations and individuals who have an expertise in this. And then I think it's been mentioned that this white paper is extremely silent on 2 things. Number one is on capitalizing on the South African diaspora. So these are South Africans who live abroad, or any other person who has a emotional or financial link to South Africa. How do we capitalize on them? And I think that's an important part of any immigration policy, is to say, how do we keep a close relationship with those of our people who live abroad? And I think that's extremely silent. And then also in the realm of labor migration, I think that there is very limited mention of how to address unskilled laborers or so to speak, economic migrants who wish to come into the country. We talk about a point-based system, but I think we need to ask ourselves, how will this point-based system look, and will it be attainable? We absolutely might not want to attract people who have a criminal record or who pose a security threat to the country, and that might be part of the points-based system, but it has to be attainable for most people who do not have a criminal record, who do not pose a security risk. And we know that proportionally migrants have a much lower propensity to commit crime or to be involved in serious crime than local populations. And that's something that we see all across the world. There's plenty of evidence on that. So I think the white paper is a little bit silent on these two things. The final comment I want to make is about collaboration amongst ourselves as the social justice cluster, if I can call it that. I think since mid-December, when this was published and the call for comments was made open until the end of January, as it was initially, there's been a lot of organizing and working together amongst people opposing sound and fair migration governance. You just have to open up your social media to see various entities organizing themselves and collecting submissions and wanting to submit as many of these to the department for this particular initiative. But amongst ourselves, those of us who are on this call and who think in a way that most of us on this call do, there's been a real lack of organizing ourselves together to not only make these submissions, but to make our voices heard in public spaces. And I would like to make a proposal that regardless of which organization we are representing here, that we try and find a time and a space to work together and to put up a united voice that speaks to fair and just and humanitarian-based migration governance. Because if we don't, other people will occupy that space and will fill it with hateful rhetoric. So I want to propose that even beyond the submission of inputs to this white paper, that we establish some kind of a platform that enables us to be connected with each other and enables us to speak about these very issues with one voice, so that the March and March and the Dudulas and the other entities like that are not the only voices that we hear when we open social media, but that as much as we will get a lot of flack for it, that our voices are heard as well, and our voices be the voices of reason, of justice, and of evidence driving solutions to the problems that we seem to find with ourselves. And we will at Statistics South Africa, under my section which I lead, we will continue to provide empirical data and empirical information about migrants, their characteristics and their magnitude, so that these stories can be told. Thank you so much.
Thank you very much, Diego. We will therefore move on to Fatima Lahir and Asipe Funda from Section 27.
Hi, everyone. I'm just going to get my presentation up if you can give me a few seconds. Okay. Hi again, everyone. I'm Fatima Lahir from Section 27, and I work in the Education Rights Program. I'm going to be discussing the right to basic education as it applies to the white paper. This is just a brief overview of some of our work. I want to start off with the legal framework of the right to basic education. So the right to basic education is enshrined in Section 29(1) of the Constitution, which provides that everyone has the right to access basic education, including adult basic education. Furthermore, Section 28(2) of the Constitution indicates that the best interests of the child are of paramount importance in every matter concerning the child. Just going back and emphasizing Section 29 of the Constitution, when the Constitution says everyone, it refers to all people within the borders of South Africa. This means that the right to basic education is not restricted to citizens. Next, I'd like to speak about the South African Schools Act, which is commonly known and referred to as SASA, which indicates that schools may not refuse a learner admission on the basis of nationality or documentation status, race, gender, religion, language, or disability, or the inability to pay school fees. Then there's the Circular 1 of 2020, and this is a very important circular because it came out of the court order in the case for Center for Child Law versus Minister of Basic Education. This judgment is also commonly referred to as the Phakamisa judgment. And what the circular addresses, which came out of the judgment, is that all children must be admitted into schools even if they don't have a birth certificate. Schools must accept any kind of alternate proof of identification, such as an affidavit. And this was groundbreaking because there wasn't any clarity on birth certificates and that kind of documentation required. And this judgment kind of set it straight. And the circular was then issued by the department indicating that you do not need to produce any kind of documentation if you don't have any. And schools must accept alternative proof, such as an affidavit indicating the identity of the child. Another piece of regulations that I'd like to discuss is the draft admissions regulations. And this came out after the recent amendments to the South African Schools Act, known as BELA. And the minister then issued these regulations on admissions and on capacity regulations. And why am I discussing the laws surrounding education is because the right to basic education is very clear, but it's in its implementation where things fall through the cracks. So just to briefly discuss these admissions regulations, which we've made submissions on, because they directly affect migrant people. So Regulation 13 requires that principals must advise parents to obtain documentation and refer cases to the head of department and hold parents accountable for not acquiring a birth certificate. This obliges the HOD to liaise with the nearest office of the Department of Home Affairs. And this phrase of hold parents accountable doesn't have a definition. So it's unclear whether the details entail, whether the definition entails administrative sanctions, disciplinary measures, or even criminal liability. And this phrase of hold parents accountable suggests a very punitive relationship between the Department of Basic Education and parents, when what is actually needed is a supportive one. Schools are not equipped to enforce compliance with civil processes, nor should they be required to do so. Moving on to 13.7c, which requires parents to submit valid proof of residence in various forms, including an affidavit supported by additional documentation, such as a bank statement or a letter from a property owner. And this requirement is very disconnected from the lived realities of many migrant parents, and also just the general poverty line in this country, which currently sits at 55% of the population. For such families, producing a bank statement, obtaining a letter from the landlord is practically impossible. Regulation 16 forces vulnerable migrant families to obtain birth documents from unsafe countries of origin, placing them at risk of creating unconstitutional barriers to children's access to basic education. Regulation 17 aims to compel officials to hold parents accountable for obtaining birth certificates, a coercive requirement that risks punitive interpretation. Any referral of undocumented parents to the Department of Home Affairs exposes learners to the risk of deportation or other adverse immigration consequences. Parents may be deterred from enrolling their children in a school or at all, fearing that contact with school authorities could lead to immigration enforcement. The white paper in its current draft revised stage does not explicitly infringe on the right to education. However, there are many cracks which then place the burden of proof on migrant families, especially in this current climate of xenophobia in South Africa. The burden of proof is then placed on families who obviously don't understand the permit that they are given. In certain cases, where now the Section 22 asylum seeker permit indicates, for example, that you will not be receiving a study permit. Families are not aware of what this exactly means. Where study refers to further studies, not the right to basic education, and families are then not properly advised of these kinds of laws, and therefore puts them at a back foot of not being able to exercise their rights. Just looking through some of the cases that we see in our advice office, and to speak to some of the practical realities on the ground. So even though the law is clear, the implementation of the law is quite poor. So we've experienced a few cases, one of them being a migrant parent who's not allowed on the school premises simply for not having the relevant documentation, which we then had to solve on a case-by-case basis. There's also been a case of learners not being admitted due to documentation, principals refusing to take in certain learners due to them not having adequate documentation, migrant learners attending independent schools out of fear. So there's a lot of unregistered schools in communities which migrant parents prefer sending their kids to due to the fact that they won't be held legally accountable. But what these schools do is they don't follow proper curriculum. And when you try and get learners back into the schooling system, it's very hard because they might have to go to a grade that's obviously not age appropriate. For example, they're 16 and need to be at a grade 4 or 5 level. And this then creates some kind of issues later on. But this comes out of fear of sending children to public schools. There's also been cases of Operation Dudula threatening admission officials. There was a GDE official who came forward to say that they received a call from someone indicating that they are from Operation Dudula, and they have come to find out that this official has been placing migrant learners in schools and kind of threatened that they will escalate this if this official continues to do so. The GDE then escalated this issue. Just to end off on a quote that was cited in our papers where we appeared as amici in the Operation Dudula matter. And I think I will just end off on that note. Thank you so much.
Thank you very much, Fatima. I hope I'm audible. Is Asipe Funda ready to join us?
Hi, Tanya. Good morning, everyone. Thank you, Tanya. I am ready. I just need to share my screen because I have a presentation here with me. Perfect. Can everyone see my screen?
Yes, we can.
Hopefully it's in full screen mode. Thank you. So I am an attorney at Section 27, and I mainly focus on access to healthcare for migrant populations. We have an advice clinic where we receive clients here in Braamfontein, but we also receive clients throughout the country, either through WhatsApp, email, or direct calls to our office. Today, I will be focusing on the right to health care and also the process that has been undertaken with the white paper and the regressive measures that we are seeing when it comes to the realization of socioeconomic rights. So Section 27 of the Constitution provides that everyone has the right to access healthcare services, including reproductive healthcare services. Our courts have highlighted time and time again that the everyone is inclusive of everyone within the borders of South Africa, whether they are documented or not. The National Health Act gives effect to Section 27 of the Constitution, and particularly in Section 4, provides that subject to any condition prescribed by the minister, the state must provide pregnant and lactating women and children under 6, except members of medical aid schemes and their dependents, with free healthcare services. I focus on this provision because this is a provision that led us taking a case to court in 2023, and I will expand on that. Section 27(3) requires the state to take reasonable legislative and other measures within its available resources to achieve the progressive realization of each of these rights. What's important here is that, yes, there are conversations about resources, about the budget, about funds that are available. However, in recognizing that there may be limitations to resources, this section acknowledges those limitations and gives the government time to progressively realize the right to healthcare. What this means is that we might not immediately have an ideal healthcare system where everyone has a sufficient number of clinics or a healthcare system that is ideal, similar perhaps to the private healthcare system, but that must be progressively realized. There must be use of resources to achieve an ideal state of healthcare access. However, what we've seen over time is that there has been a pattern of regressive legislative measures and practices as well. And when I refer to practices, I mean issues with implementation, but I will speak to that later on in my presentation. For example, the 2024 white paper came out with reservations by the Department of Home Affairs, and it sought to limit the enjoyment of socioeconomic rights by some migrant communities, including undocumented persons, asylum seekers, and as well as refugees. What happens in this case, it's when the right to health or the right to education is then, what happens is that I want to put it in the simplest form when we speak about regressive measures. What we're speaking about is when the government takes away from rights and enjoyment that were already in existence. I'll give you an example. Undocumented persons do have a right to access primary health care at primary facilities. That would be your clinics. But what we are seeing over time is that they are now being denied access even to primary healthcare facilities. And that is a regressive measure. And what we saw in that 2024 white paper is that the Department of Home Affairs sought to limit further the rights and enjoyment of migrant persons. It is important to highlight that regressive legislative measures and practices are unconstitutional. They also go against international law, which seeks the progressive realization of the right to access healthcare. Another example of regressive measures is a case that came to Section 27. We launched this case around 2022, but it had been years that Section 27 had been approached by pregnant mothers and pregnant women and mothers of young children who are under 6, who were being required to pay to access healthcare services at public hospitals in Gauteng. The correct procedure is that any migrant person who approaches a healthcare facility, particularly a tertiary healthcare facility, so a person would be referred to the clinic, from the clinic to a tertiary hospital. There, they should be means tested according to the policies that exist in that particular province. Gauteng has a revenue management policy that sets out that refugees and recognized asylum seekers must be means tested. Then the means testing is done based on the income that the person has. And based on what they can afford, they are then charged by the hospital. However, this policy should not apply to pregnant mothers and mothers of young children who are under 6 years old and lactating mothers due to Section 4 of the National Health Act. When we reached out to hospitals to inquire as to why this practice was being implemented, we were provided with a 2020 policy and policy implementation guidelines on the Patient Administration and Revenue Management Act. What this policy said is that hospitals must disregard Section 4 of the National Health Act and actually charge these mentioned groups according to the Patient Administration and Revenue Management Act. This clearly contravened the National Health Act and clearly contravened even the constitutional provisions for access to healthcare and reproductive healthcare. We were able to take this matter to court with other partner organizations such as Doctors Without Borders. And through this court case, all of these provisions, policies, regulations, and circulars that were in contravention of Section 4 of the National Health Act were declared inoperative and invalid because they offended the Constitution and also contravened the National Health Act. So this is just another example of how the Department of Health keeps on taking a step back from the gains when it comes to the rights and its enjoyment by migrant communities. The NHI is another example in regression when it comes to access to services for migrants. And this is unconstitutional. What we've noted in analyzing the NHI is that it excludes certain communities of migrants that are already recognized and have access to healthcare. Initially, but that through negotiation with the Minister of Health has been removed. Initially, it even removed access to emergency healthcare, which is guaranteed by the Constitution and international standards. And what we're seeing now is that it still excludes other recognized groups of migrants from accessing healthcare. And this is part of a challenge that has been instituted by Section 27 in the NHI litigation that is currently on pause or stayed due to procedural requirements, because there are about 8 cases that challenge the NHI. And 2 of those cases are now before the Constitutional Court, and the minister has requested that the other cases be stayed pending the outcome of the 2 cases before the Constitutional Court. And there is a possibility that the other 6 cases will be combined so that they are not isolated and heard independently before the courts. With this white paper, we initially made submissions in 2024. And in those submissions, we made it clear that the Department of Home Affairs cannot limit the rights of migrants and cannot take regressive measures against the constitutional requirements for progressive realization. We are happy to see that there is improvement in this current revised white paper. We are seeing that the department even acknowledges in the white paper itself that they cannot go against the Constitution and its empowering acts and limit the rights and enjoyments of migrant communities. And they also set out quite well the case law that has come up over the years and actually established the rights of migrant communities. But while we appreciate that, we also cannot deny the fact that most of the time, policies come out recognizing the rights of migrant communities. However, practice on the ground then goes against those ideal policies that we see on paper. An example of this is the surge we saw last year in vigilante groups denying migrants access to facilities throughout Gauteng and other provinces, actually, including KwaZulu-Natal. We received quite a lot of cases, particularly from pregnant women who had been denied access into facilities for their prenatal visits, and from also other members of the migrant communities who either needed access to their HIV medication and just healthcare in its totality. We then launched a court case late last year on an urgent basis requiring an interdict to mandate the Department of Health, SAPS, and other respondents to ensure that there is no obstructed access at facilities. In this case, we focused on Yeovil Clinic and Rosettenville. We had monitored those clinics and we had clients from those clinics who had been denied access. Therefore, we could demonstrate the established right, the harm that had been done to those clients, and the harm that would continue to be suffered by those clients in the case that these vigilante groups were allowed to continue to obstruct access to these facilities. In December, we received an interim court order that mandated the Department of Healthcare to ensure unobstructed, safe access for migrants to these facilities. Secondly, the removal of unauthorized persons at the facilities, because what we'd also had from our clients is that these vigilante groups were not only operating from the outside, but they were also even within the clinics, handling patient files and telling patients to leave the facility while they were in queues waiting to be seen by healthcare practitioners. And SAPS was also mandated to provide the assistance required to ensure compliance with this court order. So this is just one of the examples where the law is clear on how everyone has to have access to healthcare services, and particularly at primary healthcare facilities. However, what we are seeing now is the lack of enforcement by the Department of Health and other departments that are also required to intervene under such circumstances. For today, I will keep my presentation there. We have analyzed the white paper, the revised white paper. From the face of it, it appears that nothing offends the right to access to healthcare. We are exploring the issue of climate and migration out of the appreciation that there are so many other African countries that are impacted by climate change, and that means more displaced persons that require asylum. And in as much as the white paper does not detail how it foresees the climate change and migration policy, we want to put our foot in the door and actually be part of the conversation and also guide them. And I also think that what we are seeing in the revised white paper currently demonstrates the importance of civil society organizations and communities and individuals making submissions, because had there not been such a backlash and, so many submissions being made against the initial white paper or the 2024 white paper, we wouldn't be seeing this revised white paper that has taken such an improved stance. So this is also just to say that it's very important that we continue to organize and advocate and ensure that we respond to, such calls, and also to say that organizations such as Section 27 and LHR are always here to assist and help communities and individuals in, standing up for their rights. Thank you so much.
Thank you very much, Asipe. We will open the floor for brief reflections just after our next segment. But for now, I'd like to call on Balesa, who will be speaking on behalf of Lawyers for Human Rights.
Good morning, everyone. I hope you're doing well. I asked to just briefly sneak into the program just to touch on a very important point, which is on citizenship and some of the key proposals that are proposed within the white paper, and that I think are quite pertinent to a lot of the communities that we serve. It's very, long-winded, and I will try my very best to be very brief, given the time that we have. So I'm just going to touch on two or three areas that I think are very important for today's discussion. And that's mostly on how the management of citizenship would be going forward and some of the key policy proposals. So currently, the routes to citizenship in South Africa are contained within the Citizenship Act of 1995, as well as the Amendment Act of 2010. Now, the Department of Home Affairs contends that our current approach towards naturalization is very mechanical and compliance-based, and isn't catered or designed to really achieve the strategic goals in building the nation. So what the white paper contends is that there is this recognition of the strategic importance of a structured and merit-based naturalization process that will then align with our national interests, our economic priorities, as well as our social development goals. So what this means is that citizenship is now, or according to the paper, it's recognized as a fundamental legal status, which shouldn't be granted arbitrarily, but rather be reserved for individuals who have demonstrated a long-term commitment to the country's growth, our stability, and our prosperity. So the new framework essentially tries to ensure that naturalization is transparent and accountable, and there's a new way of managing naturalization applications as per the Immigration Act and various visa holders. So what this means is that there's going to be an implementation of a new points-based system where applicants are based on objective eligibility criteria, which, which include looking at their skills, economic contributions, and social impact. So there's this recognition of economic contributors or contributions in the granting of citizenship versus PR holders applying for citizenship through non-economic pathways. If we look at the merit-based pathway to citizenship and looking at the key criteria within this points-based system, the three main areas being looked at is the skills and qualifications of the applicant. So it contends that it will look at individuals with expertise in critical skills will also be prioritized. With economic contribution, it speaks to investment. So applicants who create jobs, who invest in business or contribute to South Africa's economic growth will also receive a higher ranking within the adjudication. And thirdly, looking at their social contribution, right? Looking at individuals who are engaged in meaningful community service, research, or any innovation that benefits South Africa. So within this eligibility criteria, again, we're looking at individuals who also contribute economically, right? And One of the points that we also want to get clarity on is what does economic contribution really entail, right? Would the informal economy or the informal market also be included? Because we see this big shift away from the duration of residence within the country in granting citizenship to looking at the economic contributions and social upliftment or inclusion. So, for example, economic visa holders, right, who obtained their visa through the points-based system may be considered for permanent residency after residing in the country for a period of, let's say, 3 years. But who would realistically be in a position to do that, right? So we want to highlight the type of foreigner that these provisions might cater more positively to. Those who may be in a better position to fulfill the criteria owing to economic or social standing, which would support the national goals or for strategic economic growth. But how much humanitarian consideration is also weighed in within that? Another important proposal is there's a look into the granting of citizenship that is based on statelessness. Now, currently, we have the recognition within the South African Citizenship Act and citizenship by birth within the territory, regardless of your parental citizenship. Further to that, you have Section 4.3 provisions on naturalization that then bring in the principle of jus soli into the South African context, where citizenship acquired by birth within the territory of the state is granted regardless of a parental citizenship. From our first reading, it is contended that this process or these provisions would work parallel to the introduction of these new processes. But within this paragraph, it also contends that, within the future, that legislation must only cater for a child that's born in SA, who has not taken up nationality or whose citizenship can't be determined to be eligible to apply for South African citizenship, subject to a formal statelessness determination procedure. So what we see here is the introduction of a statelessness determination mechanism for children who are at risk of statelessness and naturalization. But it would be helpful to get more clarity as to what effect this may have on Section 4.3 applications, and whether in practice would this create an additional criteria to be included, which would go against the case law that's already been established regarding this provision. So what it also contends is that in the granting of citizenship based on statelessness, that such a child would not have to wait until attaining majority age before applying, and that a special visa may be prescribed within regulations to cater for this child while their case is being investigated. And to ensure a fair and transparent assessment, a child's statelessness status could be determined through 3 mechanisms. First, through the work of the Department of Social Development as in collaboration with the Children's Court. The second option, which also speaks to a new provision in the establishment of a citizenship advisory panel. What this would do is that it would then provide expert recommendations to advise the minister in determining the qualification criteria or scorecard and balancing considerations such as national security, economic sustainability, and social cohesion. Now, we don't know what the makeup of this panel would be, whether it be varied with the inclusion of academics, senior DHA officials, civil society, or legal experts. But it would be interesting to see how that is formulated. And the third option regarding statelessness determination is with an interdepartmental statelessness committee. And this would be composed of representatives from the Department of Home Affairs and the Department of Social Development, who would conduct joint assessments and render final determinations regarding a child's statelessness status. So what we see here is, firstly, the introduction of a special temporary visa for those who are awaiting the determination of their status. and could be important to ensure that minors don't remain undocumented. But we don't know what the duration of that visa will be, because we know in practice that there is quite a backlog when it comes to the processing of these applications. Furthermore, there's a contention that the children would no longer need to wait until they're 18 to apply for naturalization. Now, if they are then given this special visa, would this visa then allow them to continue to work or go on to do their educational prospects while they await the outcome of the investigation or status? Excuse me. And finally, another clarification regarding these three options in the status determinations. Would the department then decide on which option would be best, or would they all work in tandem? So those are one or two of the biggest considerations. And finally, there's also citizenship pathways for exceptional cases, where the department recognizes that exceptional circumstances may also warrant the granting of South African citizenship outside of the standard naturalization process. And this is where the minister would then have authority to grant citizenship under exceptional circumstances based on the recommendations of the Citizenship Advisory Panel. So it would be similar to the formation of, exemption applications for permanent residency, but this would be for South African citizenship. And I think humanitarian considerations would be the most apt here in assisting or alleviating statelessness through the determinations that are made by the Citizenship Advisory Panel and its recommendations. But it would be interesting to note if these applications are also prescribed to be made within the window period, and how much would that then affect or contribute to the backlog that already exists. So without taking too much time, just my final points and for consideration, or an overview really, is, citizenship and borders and boundaries are really intrinsically connected to discourses of nationality, right? And the networks that are related to globalization. And really in the ways in which a state becomes imagined, and it's determined by who's formally included and excluded. And citizenship is the really key institutional mechanism that establishes these boundaries. So it would really be remiss, whether it is in submissions or even just the formulation of policy, to not highlight the crucial role that race and class and nationality play within the access of our state and the construction of our state, and how they play a very influential role in the implementation of immigration and citizenship policies. Thank you so much. I'll hand over to Tanya, and we can perhaps move into getting comments from the floor.
Thank you very much, Balesa. That was very, very insightful. Just to call our last panelist, Thea from the Collective Voices for Health Access.
She needs to be unmuted. Can someone unmute her?
Thanks so much to whomever unmuted me. Good morning, colleagues. It's lovely to be here with all of you, and encouraging to see so many people interested in making submissions on the white paper. I just wanted to quickly share something that Collective Voices will be doing to better support the submissions and trying to ensure that submissions that are made don't just sort of go into the void that is the Department of Home Affairs process, but can also be used for future advocacy and to try and hold the Department of Home Affairs accountable. Could someone from LHR please allow me to share my screen, please? So what Collective Voices is going to be doing is collecting and collating submissions made on the white paper. And we've put together a very short Google form to do that. So once I'm allowed to share my screen, I will show you that form, but I will also pop a link to it in the chat in case I'm not able to share my screen. So you can have a look at it there. It's just a very short Google form. And why we are asking you to share your submissions once you have submitted them is so that we can do two things to better support advocacy moving forward. The first thing that we're going to do with those submissions is to synthesize them into probably what will be like a 2-page document highlighting the number of submissions and the key issues raised across those submissions. We will then share this with you as well as making it publicly available and send it to MPs alongside a series of questions that they can then pose to the Department of Home Affairs during their deliberations over the white paper. Great. Thank you so much, Paul. Okay, I'm struggling to do it. All right, I'll just if you can click through on that link, you can see the form there. The second thing that we would like to do with those submissions is to create an online archive of submissions that the public can access to better understand concerns about the white paper. So what you'll see in the form is that, in short, we are just asking for the name of the individual organization making the submission, the contact details for follow-up questions. These will be minimal, but just so that we have those on record. A copy of the submission. This is very important for us to do the synthesis. And then either your permission to share your submission with your name or your organization's details, to share your submission without your name and organization details, or to not share your submission in that public archive. That is absolutely an option that you can choose. And I think the reason, Diego was very clear in his input about the need for us as those interested in rights, in migrants' rights, but also in the rights more broadly of everyone in South Africa and in social justice, to come together and really work together to ensure that our voices are unified and that we take up the space that we need to take up to push Home Affairs and the government more broadly to not be so regressive when it comes to immigration. And this, we really think that being able to develop a short synthesis document that can be widely shared and also provide a public archive of your submissions, highlighting all the hard work that you've done, but also making it available to the public so that people can see the very real concerns that there are about the white paper across the board from civil society. So if you have any questions, please feel free to drop me an email or pop them in the chat, and we will share the link to the form more widely, particularly as we approach the deadline for the submissions on the 15th of February. So that's all from me. Thank you so much.
Thank you very much, Thea. Before we open the floor, we have one more segment, which is also a very important part of today's webinar, how to make effective submissions. We have Renata Nhlapo, who will be guiding us through step-by-step on how to make these submissions. Thank you, Renata.
Hi, everyone. Good morning, everyone. How are you? My name is Renata Ntapo. I am currently a program coordinator at Lawyers for Human Rights and recently did submissions for the program I'm coordinating, which is #NotFitForPurpose. Particularly the submissions that I will show you are not exactly for the white papers, but I also have an outline of what they could look like, and then my submissions that I helped in creating. I will share my screen shortly. Please do give me a second. So I have submissions like outline on the left. I hope everyone can see my screen. Okay. So with these submissions on the right, those are the submissions that we did. So most of the time you do have to start with obviously your logo if you're doing your submissions on behalf of an organization, and a date to which department you're submitting the submissions to, in what way you are submitting them, and details. As you can see here, it does say submitted by Kyan, head of program, LHR, and your email. Additionally, you also have to say who prepared the submissions, the subject on why you are submitting the submission. So most of the time you do have to be respectful and cordial to whoever you're submitting the submissions to. So the people that we were submitting to were the Portfolio Commission on Women, Youth, and Persons with Disabilities. Number one, I do on my left, I do have introduction, and as you can see on my right as well, I have introduction. So the introduction on our end was, again, we are Lawyers for Human Rights. We were making the submissions on behalf of #NotFitForPurpose. This is a coalition between a couple of civil society organizations, actually not a couple, but a number of civil society organizations. We also you have to now explain what your mandate is, what you guys deal with, and why you have interest in this particular case, and why you guys are making the submissions. And then I'm sorry, I'm gonna go between both slides. So with the second, and also please do try to, one, make it legible. So it should go, it must be coherent with every way possible. It must be coherent. So with the second part, so the purpose of submissions, right? You have to write, why are you writing the submissions? Are you agreeing or are you disagreeing with anything that is being said with whatever paper, like for example, with the white paper submissions? Are you agreeing with it, with what they're saying, or are you disagreeing with it? Why are you disagreeing with? What changes would you like there to be made? And your concerns. So in terms of our submissions, our concerns were basically how the people were shortlisted for a certain position. So we really had to lay that out. What are your concerns? Why do you think this would be horrible if they, in our case, selected some of the people that were shortlisted, right? And then we also had, like, a part of our concerns was the legal framework. They were not in line with the legal framework. They did not go according to the legislation that that they need to be that they are bound by. I'm sorry, I do have a bit of a stutter, forgive me. And then additionally, we had to have the Constitution on there as well, because the Constitution does govern public administration and public appointments as well. And then on your end, on the white papers, you would have to say what legislation is being contradicted, or if they are changing. You would have to have that there. Why are you guys saying this is not the way that it should go? What does the Constitution say? What does international law say? What does the rule of law say? It would have to be more fleshy than, again, my outline. The key thematic areas. What does now them saying, like them changing some of the laws that we have in place right now, how does that restrict the concerns that you guys have and the limitations that the changes would affect? And on our end, you please do also, sorry, you do have to reference where you get your information so that they see that you did your research. That is a very important part of this, so that they see that you're not just speaking for the sake of speaking. So also, again, the headings will differ and depend according to what you want to say in your submissions, and submissions also do differ from organizations to organization, department to department. And with the ones that I'm showing you, these are from my specific department, and I've seen some that have been done by the Penal Reform Program, and they are different from our structure. So structurally, it is usually different, and depending on what your supervisor wants, you would also have to align that your submissions to what your supervisor wants and what your objective is. So with our objective here, with like the CV assessments, right, it was to show, not to have a long, like a long explanation where someone would now have to start from the beginning and read endlessly about why this person is not qualified. So we just had to have a table and just actually just show that this person is not qualified, qualifications none, easy and simple, just like that. And then with the second table as well, again, this is just to show that easy to read, easy to see, easy to understand, so that they don't take a long time. Also, please be mindful that you do not have really long submissions, because most of the time they will not pay attention to submissions that they feel are too long for them to, they have to sit through it for a long time. Most of the time they do not want that. So you do have to keep them short. And then also, again, as I said, research, as you can see here, we had a research and analysis. And with your research, you have to tie it with what you're saying above. Does it correlate? Why do you think that if A is so, and then Y is B so? So that is also a big thing that you have to do. Legal framework and constitutional framework. Also, this part is you tying your legal and constitutional framework to what you have said above, to why you don't agree, to why you do agree, to why you think certain things should be amended. This is you tying and also explaining why they would have the power to change these things, and then also move things around, amend them, and so on. I hope I'm still audible to everyone. Can I please get at least a thumbs up? Guys, I'm not seeing a thumbs up. Okay, thank you so much. Thank you, Diego. Okay, so also with us, we had the CGE commissions. You need to tie cases that will push your point further. So what has happened before that can now push this point further? As we call it in the legal world, precedent. You need to have precedent, things that allow judges, the organs of state to actually change whatever they wanted to proceed with or add to it in the first place. And then also more precedent with the NIDA shortlisting process and how that was problematic. In this case, their shortlisting was so similar to our shortlisting and how problematic it was initially. So in that sense, you need to find things that are similarly to what is going on in your case right now. So, for example, with immigration, what cases have you guys had that would tie into supporting your submissions? And then at the end, all the times you have to say the impact this would have on the people that it is governing, right? So what impact would it have? Socioeconomic issues, what socioeconomic issues, which groups would it affect? Would it affect the LGBTQIA communities more? Would it affect women more? The children, how does it affect them? Those are things that you have to mention. Again, please reference everything you have to research. Even the simplest of things, you researching shows that you know what you are speaking about, and they can't now say, oh, but you just said this for the sake of saying it. And then with your conclusion, it's basically tying together everything you've said above and also making your demands, if you guys have any demands in those, in your conclusion. Also in how they could get in contact with you guys. In our case, although this is not our full endorsement list, we did have to get endorsements, which I do think is very necessary and very important, even when it is people who are individuals and not just organizations. It is very, very important that you get endorsements because it just shows that you are not alone in the fight. So I hope I did make sense, and I hope you saw the outline that I did make. On here as well, I didn't mention recommendations because we did not need to make recommendations. But with the white papers, you guys do need to make recommendations. So this is how it would basically look on here on the left. So legislative recommendations, policy recommendations, implementations, and recommendations. So that is also a really important part for you and your submissions, and especially on the white papers. So I hope that I made sense and I spoke legibly and I was not too fast for everyone. Okay, someone says that they need the samples. I will share them with Tanya and hopefully she'll share them. If I can attach them to the chat box, I will definitely do that. And also please, always, I need to make sure I go up so that I want to show you something. Please always include your contact details because they will always want to if they want to revert back to you and communicate with you guys as well. But also you have to also include their email. It's very, very important so that they do know that you had the right email, the right people to send it to. So please do also make sure. And a key point is please have someone else who is not part of your submissions reread everything so that everything is neat, legible, and coherent. please make that a very important aspect of writing your submissions. It's really, really, really important. Thank you, everyone. Have an amazing day. That is the end of my session.
Thank you very much, Renata. And to all our speakers, thank you very much for your time and thoughtful contributions. We will be extending a bit to maybe 10 minutes past 12, just so we can have a very short Q&A session and some closing remarks from Sharon. Before I can open the floor for some reflections and question and answer sessions, regarding the recording as well as the presentation slides, please can you kindly add your email addresses to the chat function so we can share them with you after the panel or before end of business day today. And secondly, can we please give each other a chance to speak? Please keep your mics muted. And with that, we can now open the floor for some questions. Yes, Shomari, you can go first. I see your hand up. Please. Okay, we can move on to BM Kwanazi. I see your hand is up, and thereafter we can move on to Roshila.
Please unmute. People, I think, are muted and cannot unmute.
All right, apologies.
Sorry, Tanya, we can't hear anyone. No one is speaking.
Sorry, we're still trying to unmute everyone.
Can you hear me?
Yeah, I guess Shomari can now go.
Yes, thank you. Am I audible now? Thank you very much, Chair. Yeah, my name is Shomari, presenting SAROF, Southern Africa Refugee Organization Forum. Let me first thank all the presenters, despite I struggled from the beginning to join the meeting. As on a refugee perspective, understanding the situation in which we are going through, and most of the explanations, I think we know the situation, we know how the process is, but the challenge is, as one of the presenters said, implementing of those policies that are becoming very, very difficult. We have to understand and be in mind that the South African government does not want foreign nationals in the country, particularly those of us who come from within the continent. They prioritize white people who come from other places, and that's why they are minimizing their term of granting citizenship for those who have means, but those who don't have means, they're still escalating the terms of the years. It was 5 years, now it's 10. But for those who have got the money, those who have got the resources, they're given for 3 years. So we understand that from the South African government point of view, they don't want foreign anyway. We will try to do this, but I don't think there will be any impact. But we'll try to be, because we are doing advocacy. My point here will be that instead of, as you have explained, will it not be okay if we can summarize this whole revision of a white paper and see the problematic point on which we can dwell and articulate on that? If we say, which department should you do on it? For example, I see they say they want to open, they are proposing to have immigration court, for example. Now, as a refugee, how are you going to be judged in an immigration court? Looking at the rate, the number of rejections, what we find at the Home Affairs centers is because of the first interview is conducted by immigration officers who do not have the understanding of a refugee, how a refugee can come into the country. For them, any person that who comes in the country when does not have a paper is illegal immigrant, automatically. So that's why you see many people are being rejected. Now, if they want to open a case, I mean, a immigration court, why can't they have a combined immigration court and a refugee court? Because to avoid the very same thing that we're experiencing at Home Affairs centers, that would be the first point. My other point, I think maybe I like this for not to be long, is that we can combine all these problematic points that we see or that you identify, and you explain to us, for example, there is an immigration, when it comes to citizenship with the refugee status, when a person acquires citizenship or permanent resident, it is 10 years, for 10 years for you to acquire the citizenship. Now, how do we do in order to oppose the 5 years, the 10 years, to minimize it to 5 years? For those refugees who are already married to South African, for example, and they have got children with them, can't they have not a system that you say, since you are a refugee and you are married to a South African, you have proven that you have got children, you live together and all those things. Why can't this person be integrated into the community or be given a citizenship? So I was asking to say, if we can summarize this and try to look the point that we can focus on to make submissions, because it's not going to be easy for us to go randomly, make submission there, make submission there, or to choose a particular point where we will find ourselves. If we discuss much on the refugee, we will forget as aspect of citizenship. We may forget as aspect of asylum. The other problematic point, and I will finish on this, it is a first base proposal. I mean, first country principle that they are proposing. For example, I'm from Congo. A country that they will deem to be safe for me will be Burundi, Rwanda, Tanzania, those who are a country bordered with the Congo. But that we are saying is like, for me, I'm thinking it's like an abuse or trying to trash the international community, the international law into the garbage. Why? A refugee cannot be designed a place to feel safe. I'm saying even in South Africa here, we are not safe. That's why some of us feel safe. That's why we are here. Others, they don't feel safe. That's why they are returning home. And others, they don't feel safe to go home, neither to stay in South Africa. They look for protection. So you cannot to set a blanket approach to say everyone who comes from Zambia, he must go to Mozambique or any neighboring country where you deem, as Home Affairs, you deem to be safe. I think the safety of a person, of a refugee, is where the person feels, here I am safe. I think we should discuss this much so that we can understand when people are coming to look for protection in South Africa, should be not be blocked to access for protection because of certain laws that are being manufactured in order people should not come to South Africa. If they don't want to have a refugee, neither they don't want us to be here anymore, let them be clear. We are not here to come to take over the land of somebody. but we are here for protection. And those who are feeling not South Africa is no longer safe, they are returning home. But we are going to continue to exercise this as a right that we are given an opportunity for us to participate in this exercise. But I don't think if it will change anything. Lastly, when Home Affairs proposes something, automatically, as we are speaking now, for them is a law, even if it's not yet passed. We have seen this in 2017. We have seen it in 2023, and we can now start experiencing this now. That when you are applying for your paper renewal, no more email to give you a feedback that we received your things or we don't receive. You will send, they don't even answer. That tells you you will remain even undocumented refugee or irregular somebody when you are not irregular. They render you to be irregular when you are not. So all these things should be speaking. We don't need to go and do research. We are our own people who can make our own research because we have the story to tell. They have to hear us and not only based on the research, because ourselves we can see how much suffering that we face when we are going to Home Affairs offices, how much suffering we get when we are taking our children to school. We don't need research. We are ourselves the evidence of what is happening. Thank you very much.
Can I go on? Is someone sharing this or is it free for all? We just control ourselves.
Yes, we can take the next question, please.
Okay, thank you very much, and thanks for this webinar. I saw Collective Voices giving us a link to track the submissions. The point that Shomari made about this seeming to be a done-for exercise, we experienced this when we had a meeting as Africa Diaspora Forum this past week with Al Jama and its president, who is the Deputy Minister for Social Development. And the impression that we really got was that it's sort of a done-for deal, as if whatever changes are going to happen, it won't really matter, and the exercises are more like checkbox ticking. So my question or hope is that, is there a way that the submissions can be tracked? Is there any recourse that can be followed if your submissions are not considered, or submissions are just submissions? Is at the discretion of the department to look at them or not? Thanks.
Good afternoon. Can I ask my question quickly?
Yes.
Yes, there was a very important question that was raised in the chat, but I see that the person who posed the question did not raise their hands. The question asks, how does the white paper deal with the issue of the huge backlog of the unprocessed and undocumented children that were born in South Africa, the huge backlog in all the refugee and asylum seeker applications? How does this white paper deal with the addressing all those backlogs and all those people who all of a sudden are held in limbo because of these sweeping new changes that are being proposed? I'm just asking to give some clarification on that.
Hi everyone. So my question is on the RROs. So if the RROs are being moved to the border, what is the implication for the people who don't use the normal migration pathways to get into the country? So for example, does it mean that the RRO office in Pretoria gets closed, and then what are the implications for that for the people coming into Johannesburg? My other issue with the white paper right now is that it's very it sounds very anti-Black and very anti-poverty, because if you're talking about country of first safe country principle, what does it mean for people who come in via land? Because people who come in via plane might be sorted, but what about everyone else who comes in via land? The other issue for me is around access to education, particularly for children, because if the new permits means that do not give space for children to apply, for children to go to school, together with the backlog that is there for asylum permits. What happens to all the children who need to go to school for grade 1, or those who need to continue to go to school, or even new arrivals? Because that's what then those of us who work in the community will be sitting with, that we can't place children in school because their papers don't allow for them to access education. Thanks.
Good afternoon, colleagues. My name is Sarah Pierce-Jones. I'm a journalist in Cape Town. Thank you very, very much to every single panelist today. I just have some recommendations, please, for the organizations that are hosting this, that are taking part in this. Number one, maybe next time if we have another public discourse, if we can create a Google form and post the link, pin the link up into the chat so that people don't have to put their private contact information in the chat box, just to keep things a little bit safer. Secondly, please could all of the organizations consider putting together kind of an infographic which has very short bullet points that say, this is our problem with, this is an issue here, which include everything from, you know, education access, healthcare access, citizenship or naturalization. So, and sorry, also to be in a format where if someone needed to, at the last minute, they could just copy and paste, maybe make a few edits for the person who is struggling to understand the rest of the discourse or just doesn't have the time to make a proper submission that's more thought out. And I really appreciate how you've used your social media. I see Section27 and LHR on your Instagram. You were very good to combine it, to do a collab. All of the organizations involved that have social media can do this to make sure that it's one document. You guys aren't working in silos. We're all kind of working together. Yeah, that's it from my side. Thank you very, very much for everyone's time.
Can I go next?
People, we are running out of time, so I propose we only take 3 more hands. There is an order according to the hands that have been raised. Shamari, we can't take you again if you're raising your hand. So we have Roshila, Sadia, and Eldolphine, and then we'll have to close. I'm sorry. I think that we have indicated there's email addresses, and we're going to, in the closing, indicate how we can continue this conversation. We can't possibly answer all questions and respond to all the issues raised, and it really does speak to the point that Diego raised about the need for us to be organized, to be more informed. Thanks. So in that order, unless Rashila's withdrawn her question, we have Sadia and Eldolphine,
No, I
please.
haven't, sorry.
Okay, go ahead.
I unmuted, so it went down.
Okay,
thank
1
you very
minute,
much
please.
for the presentations. I just wanted, I raised a question in the chat box about the format, if this is the formal official format that was presented, and if any other kind of format that is submitted is just disqualified automatically, because I do find the format extremely off-putting and inaccessible for grassroots and individuals who might want to submit on many or all without having to reference laws and, you know, that kind of thing. And I think there's a space for that kind of submission, even if it's not pinpointing in detail, it is
point,
pinpointing
Roshila.
that
Thanks.
there's a
Sorry,
problem.
I am going to cut you. We agree. No, it's not a prescription. It's just a suggestion to assist and build capacity. Sadia?
Okay. Hello, everybody. It's me, Sadia. I'm a migrant woman in this country. As a survivor of domestic violence, gender-based violence, I just want to know what's in the law to protect the most vulnerable group, especially the women, where home affairs always been used as a weapon to intimidate and to harass us. How are you going to work with it? And secondly, because I'm not coming from a organization, how as an individual person to put my view forward? I'm in the legal battle for the last 7 years. Thank you.
Thanks, Sadia. Can I just take Aldofine? And I ask Sadia that you put your question in the chat box, and then we can respond, as Tanya said, wherever we can assist. You either can attend one of the LHR offices if it's a question on documentation, or if, as indicated, we can make individual submissions as well. They don't have to be in any sophisticated format. You just raise the problems that you are having with the current system and how this proposed policy changes will impact on your basic human rights and your human dignity. Aldofine will be the last person. I'm sorry, we can't take any more people. We don't have any more time. We run out of time. Thanks, Aldofine.
Thank you. Good afternoon. This is Adolphine from Tusimame Wanawake Africa Unite. My question is, with all of this, what is the intention? What is the really purpose of having these changes of white paper? And looking at the real issues, I posed some of the question on the charts. And looking at the reality on the ground, that you'd find families, single women, widows, you can name it. So now these families or these individuals, they've been staying in South Africa for a very long time. And there's been quite a lot of, delay in terms of issuing the necessary documentation. But now with these changes, how would that now look, or how would that now change that face of the challenge that is already happening at this point in time? Thank you.
Thank you very much for that. I'm going to now close the session. I have just posted in the chat box an initiative by Collective Voices in collaboration with other organizations that have joined to host this webinar. And we are saying that we have reached out to Wits Writing Center, and they have indicated that they will assist individuals and organizations in making submissions. And there's an email address. Marlies has very generously provided her email address if to assist in linking you if you want that kind of one-on-one assistance in making your submission. Again, in whatever format you want to, because this is a democracy and our constitution is very clear on administrative justice and informing the way in which we engage with the state and hold it to account. And I'm really sorry that we couldn't take all the hands. I think it does speak to and really affirms the point that Diego raised around the need for us to come together more often in an organized way to ensure that we are, in my many years of activism, we use the word conscientization, and that's what's needed. We need to be more informed in order to be able to engage with what is really a delinquent state. We've spoken about something we didn't speak about here today is corruption and mismanagement. And that's where our attention should be paid, not on this white paper and policy, but actually how do we hold the state to account? How do we ensure, as Section 27 said, judgments are handed down and they're not enforced? How do we, as a collective, hold hands in ensuring that judgment is enforced? We see this happening with the CACS versus Operation Dudula and the coming together of many organizations, too many to be mentioned now, in sharing information and joining hands in holding the state to ensure that those judgments are enforced and see the light of day in respecting people's basic human rights and dignity. We also see this in a matter that Section 27 is leading on in access to healthcare and holding the Department of Health to account here in Gauteng. what we should be talking about if we do come together and organize ourselves is why is there this deflection through policies that are being presented for changes, through the kind of xenophobia and scapegoating? It's because the real problem is with the neoliberal economic policies, that of privatization and fiscal austerity. What does that mean? It means cutting back public spending. And we should be saying money should not be cut back from public spending on health, on education. We should be saying deal with corruption. 2 billion has been stolen from Tembisa Hospital. That alone can give us over 2,000 doctors doing their community service in Gauteng. We have over 6,000 doctors who are walking the streets because they don't have any place to do their community service, which is compulsory, and because there is no funding to pay them, and yet the money is being stolen. So I want to close this with a loud call to adhere to what Adhere called out in his presentation, and to actually mobilize for us to deal with the real problems. We should be mobilizing, joining to call for a wealth tax that can address the huge inequalities in our country. We should be calling for a universal income grant rather than being distracted by these, which is exactly what the state wants us to do. And just to note that the scapegoating, and a very important point that Palesa raised, is that these policies pay due respect to colonial borders, the very same colonial borders that divided us and caused the current crisis that we're experiencing in the divisions, the inequalities that exist not only in South Africa, but in the region. So on those notes, and I want to again apologize that we didn't have enough time. It was an incredibly vibrant conversation. Thank you for your inputs. Thank you for populating the chat box with all your input, and we will ensure, and I'm going to call out Mpho, that we will make sure that everyone who's given us their email addresses will get a copy of the recording. We've asked, and we'll share whatever other resources have been made available. And we're asking you, please, to actually join forces, make submissions as individuals in whatever format. We know how the Freedom Charter came about, and that's what we should be doing. We should be using our power as people to hold the state to account. Thank you very much, and goodbye.